Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to look at a case that is a big deal, and I do mean to finish the case of the Queen and Senior. However, when something comes up that simply can't wait, well, Mr. Senior can wait. Let's have a look at this one. As I said, I think this is a real big deal. This is out of the Provincial Court of New Brunswick. It is Springfield Sports Club and Her Majesty the Queen, blah, blah, blah. This is the Chief Firearms Officer. So this was run for Springfield Sports Club. The lawyer on that one was Glenn Abbott, QC. QC is an honorific title which essentially recognizes people's contributions to the law, their skill, and so forth. Essentially, this means legal badass. So let's carry on here. So decision. The applicant, Springfield Sports Club, filed a Section 74 reference pursuant to the Firearms Act on December 19th, 2019. So Section 74 references are the Firearms Act procedure for challenging various certain specific kinds of decision made by the Chief Firearms Officer or the Registrar, typically refusals or revocations. The respondent is the Provincial Minister of Public Safety, represented by the Chief Firearms Officer. The subject of the application is the refusal by the respondent to approve a shooting range under Section 29(5) of the Firearms Act. More specifically, Springfield states that because the operating approval under Section 29 of the Firearms Act contained 26 numbered conditions as requirements, that these conditions are de facto a form of refusal. Springfield challenges 7 of these conditions, numbers 1, 2, 3, 15, 16, 25, and 26. The CFO removed conditions numbers 20 and 21 from the range approval in her correspondence of July 14, 2020. So 2 of them the CFO dropped, but the remaining ones are going to be the subject of this particular court battle. The respondent Chief Firearms Officer has argued, and there's going to be a bunch of sub-arguments, and I'm going to try to break down what they're saying here. So first, that because there was neither a revocation nor a refusal, but an approval with conditions, the applicant has no remedy under Section 74, and the provincial court judge does not have the jurisdiction to hear the reference. So this is a jurisdictional question, and this is probably sounding real familiar because I've currently got a Section 74 battle going on with them where they're arguing the same thing. And here what they're saying is we didn't revoke you or refuse you. We gave you an approval with conditions that you don't like, and so you can't take it here under the Firearms Act. This is a real familiar argument to me, and I don't really want to sort of spoil the issue. We'll get to why this one is real familiar to me in not too long. So furthermore, the respondent submits that the requirements with conditions listed in the Section 29 approval are the reasons Springfield received the approval. In other words, Springfield was approved to operate a range because these conditions were being met at the time of the approval. So this seems to be a couple of things. First, when they make a decision, they're supposed to give reasons. So they're saying these are the reasons. And it seems to me like they might be trying to say, listen, these aren't conditions. These are just kind of our thinking on things, which seems a little strange to me. We'll get to sort of see this argument a little further when we go on. They also say, in the alternative, the Chief Firearms Officer states that if the court determines it has jurisdiction, then the CFO's decision should be upheld. So court, if you think you can hear this, we're saying you can't, but if you can, you should say we're right and we should win, which of course, obviously they're going to argue. So question and issue. The question is, does the Chief Firearms Officer have the authority to grant an approval of a license with conditions, or is the Chief Firearms Officer creating and imposing extra operating conditions as mandatory conditions upon the applicant? At issue is the authority of the Chief Firearms Officer and to what extent she may prevail over the division of authority and responsibility between the Chief Firearms Officer, the operator of a firing range, and the user of the range as delineated in the Firearms Act and the regulations, both federal and provincial. What does this mean? Well, the law in terms of the Firearms Act and the related regulations essentially parcel out certain responsibilities. The Chief Firearms Officer is responsible for essentially deciding, is this range layout and so forth safe? But the operator of the firing range, the people running it, have certain responsibilities as well in terms of how people shoot there, what things are allowed and what aren't. And the user of the range obviously has some responsibility as well. I am a user of shooting ranges. When I go to the shooting range, there are certain safety rules that, of course, I will follow because obviously, You've got to control your muzzle direction. You've got to make sure that the firearm is only loaded at appropriate times. You've got to make sure that your, finger only approaches the trigger when you actually want to hear the noise bang, and not those times when bang would be exceedingly inappropriate. So, the user obviously is going to have some of these responsibilities as well, and they kind of envision that certain things are handled by certain people. So what the court here is saying is that the Chief Firearms Officer's conditions seem to want to tinker with that and to move those divisions around. Now, when you think, how are they going to move those divisions around? Well, they're probably going to move power to themselves, right? And they're probably also going to put more restrictions on the operator of the firing range, because that way the CFO in turn ends up with more control. Let's look a little further as to what's going on. So it starts out with the preliminary issue on jurisdiction. So as a starting place, the Chief Firearms Officer wants this whole case thrown out because they say it's in the wrong court. This is actually a very common argument these days, and it's really unfortunate. So the preliminary issue is whether a provincial court judge has the authority to determine the matter as a reference under Section 74 of the Firearms Act, since Springfield did not receive a revocation or refusal of their renewal, but rather an approval with 26 conditions. Springfield contends that the legislation only allows for the approval or rejection of approval of a shooting range, not an approval with conditions, and therefore argues that the approval with conditions is in effect a refusal. The Chief Firearms Officer argues that Springfield's license was approved with all conditions having been met, and because there was no refusal or revocation of approval, the court has no jurisdiction. Furthermore, counsel contends that the applicant's only means of seeking a remedy would be before the Federal Court of Canada. So again, this is really common. They say, listen, you can't fight this here. Quite commonly, they try to bring this argument to say you can't bring this in provincial court, and sometimes they're successful. But the reason why they want to push this off to federal court is a much more formalistic, it's much more rules-based. There's sort of stricter standards for what evidence you can bring and what evidence you can't. It's also much more expensive, so it makes it much more difficult for people to bring these proceedings. A self-represented litigant can manage just fine, usually, assuming that they can form legal arguments and, that they have some evidence. But it's possible for them to, to manage in a Firearms Act proceeding under Section 74. There's various sort of rules that make that possible. Federal court, not so much. You do not want to go into federal court without a lawyer who's quite experienced with federal court matters. So this is designed essentially to reduce access to review, to discourage access to review. That's really what's at stake here, is can people bring these applications cheaply and inexpensively? So the applicable section in the Firearms Act is as follows. So reference to judge of refusal to issue a revocation. So subject to subsection 2. And I'm going to skip to the bit that actually matters here, which is C. A provincial minister refuses to approve or revokes the approval of a shooting club or shooting range for the purpose of this act. The applicant for or holder of the license, registration, certificate, authorization, or approval may refer the matter to a provincial court judge in the territorial division in which the applicant or holder resides. So decision by provincial court judge. On hearing of a reference, the provincial court judge may, by order, A. Confirm the decision of the Chief Firearms Officer, Registrar, or Provincial Minister. B. Direct the Chief Firearms Officer or Registrar to issue a license, registration, certificate, or authorization, or direct the Provincial Minister to approve a shooting club or shooting range. Or C. Cancel the revocation of the license, registration, certificate, authorization, etc. So these are the options that the provincial court judge has in terms of what they can do as remedies. The issue of jurisdiction was considered in Runkle v. Alberta, Chief Firearms Officer, and they give the citation. Although the subject in Runkle was the issuance of a change in conditions of a license to transport, Mr. Justice Marceau did consider whether the provincial court had the jurisdiction to consider whether this was a refusal by the Chief Firearms Officer under Section 74. The Honourable Justice held that the approach of the CFO that there was no remedy available before the provincial court once an authorization was granted would not comport with the intention that Parliament had expressed in Section 74. Runkle v. Alberta. I wonder, do we know anyone by the name of Runkle? Oh, right, this was my case. This was when I fought them. Or at least the last time I fought them, not the current time. So, yeah, I'm kind of feeling a little proud of this one because at least I helped out. I had an impact here. So I like that they're using my case here, and fantastic. So he stated in paragraph 25, obviously, Parliament wished to create a procedure for review of the Chief Firearms Officer's decisions for reasonableness only by a tribunal which was more accessible and affordable than the procedures in superior courts of the provinces or the Federal Court of Canada. Further to that, in paragraph 36, I agree with Kaufman J. and the Queen and Isaac Frank Dick, and they give the further description there, that the refusal to grant an unconditional license is a refusal to grant a license. And at paragraph 37, as I said earlier, it is cold comfort that the holder of an authorization can seek remedy in the Federal Court of Canada because a provincial court has ruled that it has no jurisdiction in the matter. In New Brunswick, being an opt-in province with a provincially appointed Chief Firearms Officer, the applicant would most likely have to pursue a remedy through the Judicature Act of New Brunswick. So basically, my case involved them putting a bunch of conditions on a authorization to transport. I didn't like those conditions, so I brought a challenge. And they said, listen, we've given you an authorization to transport, so you can't challenge it in a Section 74 process. The court didn't agree with that. In particular, there was a point in the hearing where the council was asked essentially, what happens if the only approval that they give is they say, we're going to approve an authorization to transport, but only to take it to the police station for destruction rather than to go to the range as the person is asking for. And they'd essentially said, well, you can't bring a Section 74 application in that case, which didn't go over well, I don't think. All right, so decision. The preliminary issue on jurisdiction is answered in the affirmative for the applicant. What does that mean? Well, it means that Springfield wins on jurisdiction. That is a very awkward phrasing, but Springfield wins. The court finds that there is jurisdiction. The court accepts the reasoning of the applicant that by granting an approval with requirements containing 26 conditions and asserting that this falls outside the purview of a Section 74 review, the minister would effectively remove the right of the applicant to apply for a review. The conditions cannot be properly described by the respondent as reasons. They are in effect what is stated in the approval document, that is, they are conditions on the approval. By maintaining that it is within the authority of the CFO to add requirements or conditions without a right of review, this would allow the CFO to continuously add more conditions, expanding their authority without any recourse by Springfield. So a couple of things to break down here in terms of the ruling. First, if you think about that they can put these conditions and that you can't apply for a review, well, how far would that go? Let's say you're running a shooting range and they say, we are approving your shooting range. However, you can only fire firearms that shoot over 10,000 joules at this range. Well, those were recently banned by Order in Council, so that would create a range where you cannot legally fire any firearm. So that would be, that's a condition, but they're saying that you wouldn't be able to challenge that as a refusal because that wouldn't count. That's sort of an extreme example where it makes the range impossible to use. But let's say it makes the range really difficult to use. We say, your range is approved, but we're only going to approve it for use every Tuesday between the hours of 2 p.m. and 4 p.m., when, of course, most people are working. That creates a range that you can theoretically shoot at, but it's not going to be a popular range. You're not going to have a whole lot of people signing up to shoot during that 2-hour window on Tuesdays only. Should that be challengeable? Well, obviously, I think. So the court is essentially pushing back against this attempt to oust Section 74 reviews as a thing. They also seem to be arguing that these conditions are not actually conditions, they're just reasons. And, these aren't limits on what you can do. They're just reasons why we granted the approval. I think the court is going, nah, you're calling them conditions. So you don't get to play that game. In effect, this is what had happened. Mr. Cairns, the president of Springfield, testified that earlier approvals had approximately 6 conditions attached, and now the most recent approval has 26 conditions attached. They seem to be kind of tightening the ratchet. Do you ever think that they say, hey, you know what? We asked for some conditions previously and we don't think they're appropriate or necessary anymore, and we're going to stop asking for them? I kind of doubt it. I haven't heard of it in any event. So, I mean, there might be a situation, but typically they are adding more and more restrictions is what they want to do. So Springfield claims that some of these conditions have changed or expanded the Chief Firearms Officer's authority or transferred responsibility to Springfield. The applicant's only recourse is a Section 74 reference if they wish to have the decision of the Chief Firearms Officer reviewed. The CFO made a determination to grant an approval of the shooting club with conditions without providing reasons. The applicant has no knowledge of the reasoning of the CFO. This is a problem in administrative decision-making, which this is an example of. They're supposed to provide reasons why they make the decisions so that it can be intelligible to the person and potentially to a future court to say, hey, okay, this is why they made their decisions. Because sometimes a decision might be reasonable or unreasonable depending on what those reasons are. So as an example, let's say you apply for a shooting license and they say, you want a firearms license. They say, hey, listen, we're refusing your firearms license, and they give no reasons. Well, you don't know why. But let's say we're refusing your firearms license because, as it turns out, you have all of this violence in your history. That might be a reasonable reason to refuse somebody a firearms license. But let's say it comes back and it says, we are refusing you a firearms license because we really don't like your name. Like, that's a very silly name, sir, and we are rejecting your firearms license because we just could not bring ourselves to print it on one of our cards. That would be an unreasonable reason. So it's important to gain access to what they're thinking when they make these decisions. So it was therefore determined that the Chief Firearms Officer, as respondent, should proceed first to provide the applicant with her reasons. This is actually something that comes up in a lot of these proceedings. In fact, I would suggest that the case law says that the Chief Firearms Officer should present first, notwithstanding the fact that they're the respondent. Ordinarily, when you bring a court proceeding, the applicant is the first person to present. However, because at these kinds of hearings, the Chief Firearms Officer can augment their reasons, typically the courts have found that the Chief Firearms Officer should present their side first, and that the applicant then essentially takes the place of the respondent. It's a bit of an unusual procedure, but it's not an unknown procedure. This is something that you can actually find in some other contexts. Legislation and regulations. They're going to go through a bit of the law here. The approval and revocation of shooting clubs or ranges is governed by the federal legislation under the Firearms Act of Canada, the Shooting Clubs and Shooting Ranges Regulations, and standards for design and construction of shooting ranges in New Brunswick. Now, this is not actually legislation, that last document. That is just a standards document. So in New Brunswick, the Firearms Act is governed under the authority of the Minister of Public Safety of New Brunswick, who is designated by the Lieutenant Governor and Council. The Minister designates a Chief Firearms Officer and may delegate such duties and functions to the Chief Firearms Officer as specified under the authorization in Section 29(4) of the Firearms Act. Under Section 29(1) of the Firearms Act, shooting clubs or shooting ranges may only operate under the approval of the Minister, and the Minister may approve the club if it complies with the regulations under paragraph 117E. So 117 is the provision which allows for the Lieutenant Governor and Council to make regulations, and paragraph 117E is the authority for the establishment of regulations for shooting clubs. This is a complicated bit of stuff that basically talks about how the law works. So first they can set, the rules, and then regulations can be set and so forth. So this has been done. The Shooting Clubs and Shooting Ranges Regulation is the specific regulation created for the purposes of establishing and operating a shooting club under paragraph 117E of the Firearms Act. And I'm going to skip over. It just says that they can make regulations, so of course they do. Under Section 29(3) of the Firearms Act, the provincial minister may revoke the approval for any good and sufficient reason, including, without limiting the generality of the foregoing, where the shooting club or shooting range contravenes a regulation made under paragraph 117E. The notice to refuse or to approve or revoke an approval of a shooting club must include reasons under subsection 29(6) of the Firearms Act. A notice given under subsection 5 must include reasons for the decision, disclosing the nature of the information relied on for the decision, and must be accompanied by a copy of sections 74 to 81. Now you might be saying, what is sections 74 to 81? These are the processes by which you can bring a review. So they're essentially saying when they give a refusal or a revocation, not only do they have to tell you why they're doing this, but they also have to include stuff about how you can challenge their decision. So they have to say, here is how you fight us if you disagree. I think that's a great thing. It helps improve access to justice because it requires them to inform people that they have rights to challenge this, that they can fight this. They don't have to just say, okay, well, I guess that's the decision and I'm stuck with it. The roles and responsibilities or authority of the various parties are delineated under the shooting clubs and shooting ranges regulations. They are the chief firearms officer, the operator of a shooting range, and the users of a shooting range. And there's going to be a lot in here about sort of deciding who has which responsibilities. Persons who wish to operate or to establish and operate a shooting range or shooting club must provide all of the information and documentation as set out in sections 3 and 4 of the regulation. The operator, the person approved under section 29 of the Firearms Act to operate the shooting range or club, has the authority and responsibility under sections 5, 7, 8, 9, 11, 12, 13, 14, and 15 of the regulations. So these sections are basically things that the operator of a shooting range must do. So I'm going to summarize this because this is a big giant wall of text. So they shall ensure that the discharge of firearms does not endanger the safety of persons at the shooting range or in the portion of the surrounding area described in paragraph 3 sub 2 sub a, which is basically anywhere else that a bullet might land. So that includes ensuring that the design and operation is such that projectiles discharged from firearms will not leave the shooting range if they are discharged there in accordance with the safety rules, which means essentially, if a user is not following the rules, that's not on the range. That's on the user themselves, because obviously the range doesn't have the ability to mind control every user and force them to follow the rules. That said, shooting ranges in Canada are incredibly safe. The one I go to has been in operation for decades, and so far as I'm aware, has never had a firearm-related injury or safety event. My understanding is that there have been some injuries, but they're things like somebody falls and and hurts themselves in that fashion. Nothing gun related. And promotes the safety of all persons, including by accommodating any adaptation that may be appropriate given the nature of the shooting activities. That the shooting range has an adequate warning system to warn persons that they are entering a shooting range and to inform them, when such is the case, that shooting activities are taking place at that time. So you don't want anyone wandering into a shooting range by accident. C, appropriate safety rules are applied. So you got to follow safety rules. You got to have safety rules. D, the safety rules are posted in a conspicuous place on the shooting range. So you got to be able to find them. E, if more than one person is simultaneously engaged in shooting activities, that a person acts as the range officer. On some ranges, this is accomplished by having a permanent range officer. On other ranges, this is accomplished by usually saying that the first person to the line is the range officer or whoever else they agree if it's a different scenario. The operator of a shooting range shall ensure that every person who indicates an intention to use the shooting range for the first time is informed of the safety rules. And this is typically part and parcel with having it posted in a public place. And no person may use a shooting range for the first time without having received the information referred to in subsection 1. So those are the rules that kind of limit what the operator does. Those are the responsibilities of the people running a shooting range. Compliance with safety standards by the operator. Section 5 of the regulation specifically relates to compliance with safety standards and sets out the operator's responsibility to ensure the discharge of firearms does not endanger the safety of persons in the range or in the surrounding area. This is achieved first by the design of the shooting range. The design is regulated under Section 5A, and the document, the Standards of Design, was developed under the regulation in accordance with the Firearms Act. So basically, there is a document that says what things a firearm, range should include. Measures to mitigate, ricochets, measures to mitigate various other things, just to prevent bullets from leaving the range, which of course nobody wants. The day-to-day responsibilities under Section 5 of the regulation included in the operation of the facility include briefly establishing a warning system and appropriate safety rules that are conspicuously posted, establishment of a range officer system, and ensuring all persons using the range are informed of the safety rules. The operator is also responsible for maintaining insurance, submitting appropriate documentation, keeping records of members and guests, and reporting changes affecting documentation and reporting personal injuries. These are all sorts of requirements that they have. Users of the shooting range have responsibilities under Section 6 and 7 of the regulation. They are prohibited from using a restricted firearm or a prohibited handgun at a shooting range unless they are a member or an officer of an approved shooting club or a guest of a person who is a member or an officer. They must receive the information on the safety rules of the shooting range. Authority of the minister to revoke approval. The minister has an overarching authority to revoke the approval of a shooting club under Section 29(3) of the Firearms Act. A provincial minister may revoke the approval of a shooting club or shooting range for any good and sufficient reason, including, without limiting the generality of the foregoing, where the shooting club or shooting range contravenes a regulation made under the paragraph. So when we see that language, what that means is any good and sufficient reason is enough, but they provide this, the breach of the regulations as a specific example of something that would be a good and sufficient reason. So, authority of the Chief Firearms Officer to oversee continuing compliance. The operator has responsibilities for continuing compliance under Sections 8, 9, 11, 12, 13, and 14, including, among other things, maintaining insurance, updating and submitting documents, reporting personal injury reports, and so forth. The specific and limited authority of the Chief Firearms Officer to oversee the operations of a shooting club is also found in the shooting club's regulations. In addition to the operator being required to provide evidence of compliance every 5 years under Section 9 of the regulation, the CFO may request evidence of compliance under subsection 10 sub 1, but no more than once a calendar year. And under subsection 10.2, the CFO may make a request more frequently, so more frequently than once a calendar year, if he or she A, has received in the preceding 12 months, so 1 year, a personal injury report or a change report. So if the range has suffered an injury there, then they can ask for compliance more regularly. And if there's been a change to the range, then they can ask for more information. Or B, has reasonable grounds to believe that the continued operation of the shooting range may endanger the safety of any person. All right, so seems reasonable enough, right? Standard of review. Standard of review for reference to the provincial court is uncertain. The Firearms Act provides for reference and states that the provincial court judge shall hear all relevant evidence. The provincial court judge therefore conducts a hearing, and it is the first time that the matter is heard. Unfortunately, the Firearms Act was not very well designed. And this, I think, is apparent to all participants in the legal system who end up dealing with it. Normally, it should provide for what the standard of review is, which is essentially how much evidence do you need to win? How thoroughly do you need to show that it's wrong? Because there's various standards that are sort of recognized in the law. One standard is simply correctness. Do we agree that the firearms officer's decision was the right one? But we also have standards like reasonableness, which is not just do I agree with this, but is it within the boundaries of a reasonable decision? Is this decision made in a fashion that itself is reasonable? And, is the outcome sort of one that falls within the range of possible outcomes? Reasonableness as a test that has a whole lot of case law that, sort of governs it, but it's a well-known legal test. So these are examples of possible standards of review. There are also, even higher standards of review. So courts have had to grapple with what the appropriate standard of review is for these things, because unfortunately, the actual legislation itself is silent on that point. This is not how I would have written the law, but it's how they decided to when they wrote it. So we're stuck with it. Section 75. At the hearing of a reference, the provincial court judge shall hear all relevant evidence presented by or on behalf of the Chief Firearms Officer, Registrar, or Provincial Minister, and the applicant or holder. So all relevant evidence is an important term because the Supreme Court has essentially said that's very broad. At the hearing of the reference, the burden of proof is on the applicant or holder to satisfy the provincial court judge that the refusal to issue or revocation of the license, registration, certificate, or authorization, the decision or the refusal to approve or revocation of the approval was not justified. So what that means in terms of the burden of proof is that if no other evidence is called, then the Chief Firearms Officer or the Registrar wins. There's got to be enough evidence to show that they made a mistake. So various courts have considered whether the standard is one of a trial de novo, which means a trial from the outset. It's a brand new hearing. So that would mean essentially that once you bring these applications, you throw out essentially everything that came before, and you just look at, what gets proven at the actual hearing. Deference with amplification, or some other type of hearing. So what deference with amplification refers to is that some courts have said that you do need to apply some deference to the chief firearms officer, which means that you essentially presume that they know what they're doing and that they're making good decisions until and unless that is countered. But amplification allows, these hearings actually specifically allow for new evidence and new information that may not have been before the person who heard the original or made the original decision. Some or a lot of admin sort of reviews don't allow for that kind of amplification because they say, well, you should have brought the right application in the first place. If you left things out of your application, that's on you. But because of the nature of a Firearms Act application, sometimes there's additional information, and sometimes, for instance, there's no way to force the chief firearms officer to do a review, to investigate things. So this allows you to bring your own information, your own investigation potentially. So reference process as de novo or sui generis. All right, so you might be saying, what do these mean? Law, unfortunately, still loves Latin, and I don't love Latin. So reference process as de novo means as a new process, like it's a new hearing and we start from scratch at the reference hearing. Sui generis means sort of a thing into itself, a unique entity. And I usually, when people ask me whether, which of these categories it is, I think that the case law says that it's a sui generis process, which means it's its own weird thing. Firearms Act stuff is basically this unholy hybrid between administrative law, criminal law, and stuff we just made up for Firearms Act stuff, all kind of wedged together in this big unhappy lump. And again, this is not how I would have written the legislation, but it's how they went ahead and did it. This is a constant source of frustration if you are sort of in the field. I would love to be the guy who gets to rewrite this. Unfortunately, I suspect that anybody who goes in to fix it is just going to break it worse. So, dear legislators, if you want to actually fix your problems, give me a call. But otherwise, don't mess with it. If you don't know what you're doing, don't tinker here. Because it's taken the courts a long time to figure out something even vaguely workable. And yeah. And it's workable enough that that there's strong opposition by the chief firearms officers that they seem to want to shut this process down. All right, so let's continue on here. In Pogson and Alberta, chief firearms officer, Justice Slatter came to the conclusion that that would have been a Justice Slatter, came to the conclusion that the standard of review should vary depending on the exact circumstance of the reference, and cited Bond and British Columbia chief firearms officer. These are exactly the cases I think are relevant, and so fantastic. In summary, if the applicant simply attacks the decision as unreasonable on its face, the approach would be closer to that of a judicial review, or to a classic judicial review, rather. If instead the applicant calls extensive new evidence materially affecting the persuasiveness and reliability of the information on which the chief firearms officer acted, then the approach will appear like a de novo hearing. So you're saying, what does all that mean? Well, if you don't have any new information or new evidence and you just go in and you say their decision was bad, then they're going to apply something that's effectively like a reasonableness standard where we provide some deference. We assume that the chief firearms officer made the right decision unless you can show that they didn't. And so that's what they're talking about sort of in the classic judicial review aspect. But if there's a whole bunch of new evidence, then it might end up being that we can't really rely on the chief firearms officer's initial decision-making because there's all this new evidence that they didn't have. So as a sort of really exaggerated example, let's say the chief firearms officer rejects your application for a firearms license because they say, listen, you obviously can't have a firearms license. You are a multiple murderer. You have killed 12 people. We are obviously not giving you a firearms license. And you go in at this, hearing and you say, well, actually, it turns out that guy he exists and he has the same name and birth date as me, but he's a different guy and he's sitting in, this federal prison right now. Obviously, that's not him applying for this firearms license. I'm a completely different person. Well, then they're not going to rely very heavily on the chief firearms officer's initial decision, right? They're going to say, okay, well, we have to throw this out and now determine if this guy here is somebody who, based on this new information, should have a firearms license. So that's kind of a ridiculous example, but I do like ridiculous examples for illustrating points. They do well for that. So this is a weird thing. This is why they say it's, unique, is that this kind of sliding standard for how the court deals with the standard of review is a little unique, but I think it is very appropriate for the very unique and unusual way in which evidence is heard in a Firearms Act hearing. Quite frankly, I think that the courts have hammered out something that makes a lot of sense within the confines of the legislation. So, reference process as standard of reasonableness. So, paragraph 29.3 of the Firearms Act provides powers to the minister to revoke approval if there is good and sufficient reason under the Act, including a contravention of the regulations, and for the chief firearms officer to order evidence of compliance by the shooting club based on reasonable grounds of belief for the safety of any person. So, if they don't think you're following the rules, they can maybe ask you to show that. This is a review of the decision of the chief firearms officer, whose decision must be made for good and sufficient reason and on reasonable grounds of belief for the safety of any person. Although it has similarities to a trial de novo, it is not simply a fresh hearing where the judge can replace her decision with the decision of the chief firearms officer. It is clear that the decision of the chief firearms officer must be proven to be not justified. So what the court is saying is that a reasonableness standard is being applied here, and they're kind of describing it, which is good. In addition, the chief firearms officer is not limited to the reasons provided at the time of the decision, nor is the applicant limited only to evidence that was available before the application was filed. This is important, right? The chief firearms officer can actually bring new reasons. And so what you sometimes see is somebody who applies with the chief firearms officer. They say, I want a gun license. And the chief firearms officer says, no. You're having an ongoing fight with your neighbor, and your neighbor doesn't want you having one. He says you're dangerous. You've had a few police reports. There hasn't been any charges, but we don't really think that bringing a gun into this situation is really what's called for. Dear gun owners, get along with your neighbors. There are lots of Firearms Act cases that involve people having feuds with their neighbors. Don't do it. But let's say in between making that decision and actually bringing it to court, things boil over, and you get into a fist fight with your neighbor and are now charged with assault. The CFO doesn't have to stick to what they said before. Now they can say, listen, we had those concerns before, but also now he's been charged with assault. And the applicant, of course, can bring new evidence because the applicant doesn't really have the opportunity to present evidence until they get to these hearings. The decision of the chief firearms officer must be shown to be an error by a balance of probabilities. That's essentially a 50% plus something standard. So if you think of, sort of the scales of justice, this isn't like a big switch. This is just a tiny, tiny nudge from balance. Reference is not a criminal proceeding, and the burden on the applicant does not require proof beyond a reasonable doubt, but rather is based on the preponderance of evidence. If the applicant fails to meet this burden, the chief firearms officer's decision stands. With the decision of Canada, Minister and Citizenship of Immigration, and Vavilov, which is basically the case currently on reasonableness, the Supreme Court determined that the framework of standard review for administrative bodies needed clarification. And they decide this like every 5 to 10 years. The former standard of review framework under Dunsmuir was found to be unwieldy and unduly complex, and the Supreme Court replaced the various standards with a general rule of reasonableness. In consideration of that decision and the unique hearing contemplated by the legislation under the Firearms Act, this court is satisfied that the standard on which one determines the decision of the chief firearms officer is one of reasonableness. This standard is built into the legislation with authority given to the chief firearms officer to revoke an approval for any good and sufficient reason. The judge may receive all relevant evidence, including new evidence that comes to fore after the application was filed. All right, so complicated stuff there. Standard of correctness. So correctness is a different legal test. And I know this probably has some of you guys having your eyes glazing over. However, Lots of legal cases are won and lost based on the standard of review. As a layperson, this stuff is probably, I recognize, kind of boring. As a lawyer, this is where winning happens a lot of the time, because you can end up in a case where they'll say, listen, on a standard of correctness, I would have given you what you wanted, but we find that the standard is reasonableness, and that gap in between those two standards is where you live right now, and so you don't get what you want. People fight over the correct standard of review because you want a favorable one. So, standard of correctness. The court notes that although this hearing is a reference and not an appeal, for questions of law, the standard of review would be correctness as stated in Vavilov. This means that the applicable standard is to be determined with reference to the nature of the question and to this court's jurisprudence on appellate standards of review. Where, for example, a court is hearing an appeal from an administrative decision, it would, in considering questions of law, including questions of statutory interpretation and those concerning the scope of a decision-maker's authority, apply the standard of correctness in accordance with Husen and Nicolaisen. So, what does that mean? Well, when they're asking questions that are sort of interpretations of the facts, the standard is reasonableness. But if we're asking the question of, do they get the law right? The standard is correctness, which is a much stricter standard here. All right, that's enough standard of review. We're probably all glazing over here. Let's move on to the fun stuff. Background. Lisa Rosknall, and I hope I'm pronouncing that right. It might be Alyssa, might be Elisa. I'm making my best guess here. Chief Firearms Officer for the province of New Brunswick, had been Chief Firearms Officer for approximately 7 months prior to this hearing. The Chief Firearms Officer who had granted the conditional operating approval was Mr. Christopher Michael Hand. So that's got to be a really terrible way to start the job. Hey, welcome aboard, and now you have this giant legal proceeding. Oh well. Ms. Rossignol had been with the Provincial Firearms Office since 2007 and has worked in every position at the Provincial Firearms Office, from an administrative assistant to her present position as Chief Firearms Officer. Wow, this has actually got to be one of the few places where you can literally work your way up from the mailroom still. So, cool. I think that's kind of a good thing. So, prior to her position as Chief Firearms Officer, she was Operations Manager and would have been considered the second in command for Mr. Hand. Okay, so maybe she had some involvement with that prior decision. The Canadian Firearms Program is operated either by the individual province, which appoints a provincial CFO, or by the RCMP, which would have a federal Chief Firearms Officer. In New Brunswick, the decision was made to operate under the provincial format with the CFO. The Chief Firearms Officer is designated by the Minister of Public Safety for the province of New Brunswick. Chief Firearms Officers are responsible to approve or refuse licensing, both individual and in business licensing. They inspect, grant shooting range approval, review the transfer of firearms between individuals and businesses, grant authorization to transport, and authorization to carry. Chief Firearms Officers also deliver the Canadian Firearms Safety Course and the Canadian Restricted Firearms Safety Course on behalf of the Canadian Firearms Program with instructors that are designated by the Chief Firearms Officer. The Provincial Firearms Office, through the Provincial Firearms Advisory Committee in New Brunswick, created a document entitled Standards for Design and Construction of Shooting Ranges in New Brunswick, Chief Provincial Firearms Office, Department of Public Safety, Province of New Brunswick, which was Exhibit A12 at the hearing. This document was created in the late 1990s and last revised in 2003. You don't need a whole lot of revision on these things because guns aren't changing that much. And most of the stuff that is really innovative is super banned, so doesn't get used at these ranges. It was created so that all shooting ranges in New Brunswick would design and construct shooting ranges based on the standards established by the document. Most other provinces use federal guidelines, which are quite different. Any range that wishes to apply for approval as a shooting range and any range up for renewal is subject to the template in this document. The overarching consideration is public safety, assuring that the discharge of a projectile is done in a safe manner. The Firearms Office will inspect to determine if the range meets the requirements under the Firearms Act, under the regulation, and under the document standards for design and construction of shooting ranges in New Brunswick. If they meet the requirements, they will receive approval. However, the approval may be partial approval because some parts of the range may not meet the standards. The Chief Firearms Officer will work with the operator to help them meet the standards. The approval can be for a period of up to 1 year or 5 years, depending on how the range is set up and what work has been done. The approval determines what types of activities they can have on the range, whether it's handgun, rifle, or shotguns. The approval will have the requirements and obligations and the limitations for each range, For example, the approval may state that if one range is being used, the other must be closed, or it could mean that only one activity at a time is permitted per range. With respect to renewals for approval of a shooting range where no changes have been made to the range, the documents that are already on file do not have to be resubmitted. However, with renewals, there is still a need for an inspection. So the inspection is basically they show up and they want to see that the range still looks like what they expect it to be. Springfield's first approval was granted in 2002. On different occasions, they were given partial approval and following that, full approvals. Their status flipped back and forth between partial approvals and full approvals on different occasions. In the most recent approval, they provided their renewal documents and an inspection was performed. Exhibit R4 is a shooting range approval for Springfield, dated January 7th, 2019, expiring November 30th, 2019. At that time, they were given an approval and a refusal. They were given an approval for part of their range and also a refusal for the ranges that did not meet the requirements. So this is something that ranges have to deal with fairly often. They're sort of going, how is it that we got a full approval last year, nothing changed, and now, or last time, and now nothing's changed, and now they're giving us a partial refusal? Dealing with the bureaucracy is a major headache for range operators in general. Chief Firearms Officer explained to the court why there was such a narrow time frame for approval. Originally, Springfield was inspected in August 2018, and they were given an approval for part of the range and a refusal for the parts of the range that did not meet the requirements. Following that, on December 2018, Chief Firearms Officer received a letter from Springfield asking for clarification on the range approval from August 18, 2018. The CFO, Chris Hand, Ms. Rossignol is second in command, and John Welshner, Firearms Officer, met with Springfield and their representatives, Mr. Cairns, Mr. Allaby, and Mr. Abbott. On January 7th, 2019, a letter was sent to Springfield stating that the approval was granted on the condition that the CFO would inspect in the following year to ensure that all the deficiencies had been rectified. The approval was effective January 7th to November 30th, 2019. The CFO further explained that 75% of ranges in the province were failing the inspections. So ranges were given partial approvals and refusals because so many of them were not meeting the minimum standards. By giving another approval up until the following year, this allowed ranges to get the deficiencies fixed or corrected. In 2019, their office re-inspected 19 shooting clubs or ranges, and Springfield was included among them. Springfield was approved with 26 conditions, and this approval was effective January 7th, 2019, expiring November 30th, 2019. One of the items for the approval was approved operational hours of the range are from dawn to dusk. The CFO was not aware that there was any nighttime shooting at Springfield. Ms. Rossignol explained that the practice of attaching conditions to the approval. Their office had consulted with other jurisdictions to see how they were issuing approvals. They aligned themselves with Nova Scotia by issuing approvals with conditions. Now, that's something that you kind of need to do with authority of law. You can't just decide that you can do things like this. So the purpose of putting conditions on the approval of the ranges was to make things as clear as possible with respect to what ranges could and could not do. She confirmed that 19 New Brunswick ranges were approved in 2019, and all of them received approvals with the 26 conditions attached. Some may have had slight variations to this set of conditions, but generally this is a generic set of conditions placed on all approvals of shooting ranges. So this suggests that they're not really thinking about a particular range and their particular concerns, but simply they've come up with what they think should be additional regulations in the law, and that aren't. And it looks to me from the outside that they kind of decided, the law should say that they have to do all these things, so we're just going to stamp that in on our own authority. You can see I have my own take on kind of some of these activities. She stated that at the time of giving the approval, the ranges were meeting the requirements stated in the conditions. If they are not, they would not be given an approval, or they would be given a partial approval. If there are questions or issues, Springfield would email the generic email account and their concern would be forwarded to the appropriate person. Whoever needed to respond would respond back to Springfield so their questions or concerns would be considered. There may be a telephone call or meeting set up depending on the issue. This is part of the approval process, which she described as a continuous approval, continuous communication between the CFO's office and the stakeholders. This situation of continuous approval and continuous communication was not as evident as was related at the hearing of this matter. The Office of the Chief Firearms Officer required Springfield to apply through the Right to Information and Protection of Privacy Act, or TIPA, in order to receive disclosure of the range inspection reports. The reference under Section 74 did not proceed immediately because Springfield did not receive the disclosure they would have expected to receive. The Office of the Chief Firearms Officer has since ceased this practice of obligating the request for disclosure to be made under RTIPA. So, the Firearms Act for these hearings doesn't actually, it's silent on the issue of what documents need to be provided by either side. And so this results in some circumstances where people say, hey, I want these documents, and they say, no, we're not going to give them to you, notwithstanding the fact that they are relevant to the proceedings and only in the possession of the Chief Firearms Officer. So they actually required them to go and file a separate application in order to get these documents, and those applications take forever. Sometimes they take years. So I'm glad that the Chief Firearms Officer in New Brunswick has ceased this practice. I wish that they would cease this practice in other provinces. It's always a question as to what they will and won't provide. Timothy Michael Cairns is president of the Springfield Sports Club. He was a reserve member of the Canadian Armed Forces from 1967 to 1974. He became the small arms instructor for his regiment. He's been shooting since then with different clubs in Ontario and Prince Edward Island. He's been shooting continuously since he came to New Brunswick in 1991. In his professional life, he has worked as a CPA and started his own company in 1993. At this time, he is semi-retired but continues to work with some of his clients on their accounting needs. His experience is varied, including handguns and long arms. He's experienced with using rifles at different distances and multiple types of handguns as well as trap shooting. He was a member of the International Practical Shooting Confederation, a worldwide organization primarily using handguns in an active sport where you move and shoot at different types of targets at different distances. So IPSC. Springfield has two types of action shooting: cowboy action using single-action revolvers, lever-action firearms, and pistol caliber and double-barreled shotguns. There's also practical pistol shooting where there's one range set up permanently for that activity. Both types of action shooting engage targets at different distances, and there is movement between barriers and different parts. Springfield is on land leased from the Department of Natural Resources and is around 30 hectares in size. Currently has 9 ranges. Some are handgun only, some are handgun and rifle. There are 2 long-range ranges, a 600-meter and a 1,000-meter range. This sounds like a really nice range. I'd love to visit it at some point. One is for future development. The facility is 11 kilometers from Maktakak. I'm sorry, I'm sure I've mangled that. Provincial Park, and 5 or 6 kilometers from the nearest housing. It is surrounded by bush and swamp. He provided the court a Google-colored printout of an aerial photo of the range, marked as Exhibit A14. Mr. Cairns discusses Exhibit A3, the actual application for shooting range approval submitted on August 2nd, 2018. Exhibit A2 is the actual approval that came back sometime later from the Chief Firearms Officer's office. Following the submission of the application for shooting range approval, the CFO identified a number of ranges that were approved and a number of ranges that were not approved. The term range is used interchangeably with bays. On the range facility, there are 9 ranges or 9 bays. With respect to the bays that were not approved, the Springfield Board met with the Chief Firearms Officer and the inspector and discussed the items that were not approved, identifying things like pitting and angles, and the concern that this would degrade the angle of the berms. He explained that the angles of the berms were in excess of those required, so based on that, the ranges were then approved. At that point in time, the bays did get approved in a letter about a month or so after the meeting. So for people who don't know, the berms are big sort of usually dirt barriers that are intended to catch the bullets. So stop those from exiting the range. And so the angle on that it matters because you don't want bullets deflecting. Bullets behave in unusual fashions. It was indicated that there would be a follow-up on the 1,000-meter range because there were rocks on it. The 1,000-meter range was originally built in 2001 to accommodate a shooting gallery. The club eventually installed electronic targets, which sit on the mantle. The targets are lower than the top of the mantle. These targets are 6 feet high and 6 feet wide. In behind the mantle, to protect the electronic components, are located sound sensors on the 4 corners, which transmit back to the firing point on an iPad where the bullet hit on the target. That is cool. So, this is a well-outfitted range. I like this range. 1,000-meter range was supposed to be inspected again. The inspector showed, and he intended to do a full range inspection in spite of the fact that only the 1,000-meter range was due for an inspection. This happens all the time. They want to say, hey, we want to inspect everything. And people are like, well, the only issue is that. Please stop trying to find extra problems. Because typically, if the inspector is going to go through everything, they're going to want to justify that trip. So Mr. Hand thought it would be a good idea to inspect the whole facility again. Yes, but good idea isn't the standard here. The full inspection was in the summer of 2019. There were still some concerns by the CFO that they had about the mantle at the 1,000 meter range. They never questioned the mantle at the 600. Springfield received the approval in November 2019. The range was approved, but they put a caveat that they had a problem with the mantle on the 1,000. There were issues with respect to rocks on the floor between where the targets are placed and the backstop itself, an area of 30 to 35 meters. Cairns agreed to do a cleanup, but the range was open. Mr. Cairns explained the reason for the Section 74 reference review. In 2018, when Springfield received the original approval for a number of the ranges or bays, there were approximately a half dozen conditions, which were standard conditions that were always on the approvals. The approval received in 2019 listed 26 conditions. So you go from 6 to 26, 20 additional conditions. That's a bit of a big deal. And obviously anybody operating a range is going to go, what? Some of the conditions were a direct quote of the shooting club regulations, but others were skewed a bit. The conditions that they have concerns with were the responsibility of the operator and not the responsibility of the chief firearms officer. The CFO informed him that the decision was made to add these conditions based on inquiries they were getting from other clubs in the province. They thought it would be a good idea to put these conditions on as best practices. Well, best practices and law are kind of different things. He was never given any response with respect to the reason behind the specific conditions, although he was provided with a response in a letter marked Exhibit A9, explaining the conditions were standard conditions similar to what they use in Nova Scotia. And this is sort of what you see typically, is that one province gets a clever idea for something they want to add, and then they get upset that other provinces aren't doing the same thing. And so you get this ratcheting effect where they keep tightening up the conditions, because anytime somebody has a genius idea for something they can add to this, then, they want to harmonize it. And it's always harmonized to the most strict standard and not the most, permissive or rights respecting standard. So the conditions challenged by Springfield, you've probably been going, this is what I've been waiting for. I want to find out what's going on here. So let's have a look at what the actual fight is. So condition number 1, the range operators are responsible for enforcing all operating conditions as noted below. So you might be saying, what's wrong with that? Well, let's see. The concern raised by Springfield with respect to the primary condition is twofold. Some of the conditions listed under the requirements are strictly related to the responsibility of the users of the facility and not the operators of the facility. The responsibility of the users fall under Section 6 of the regulations. These conditions are not the responsibility of the operators. The second concern was that some conditions are strictly the responsibility of the operators of the facility and do not fall under the responsibility of the CFO. The CFO does not have the authority to repeat rules already in effect and not under her authority. So that is kind of a complicated thing. I'll let the court explain and then I'll offer my comments here. So in condition number 1, the general enforcement clause for all the conditions is too broad and effectively makes the operator responsible for matters which are the responsibility of the users, such as in conditions number 2 and 5. So the reason why the operator doesn't want to be responsible for the user's issues is that then essentially the operator becomes responsible for supervising the users at all times. That's clearly not workable. Most ranges are sort of in remote areas. My usual range, you sort of badge in, you badge out, but there's not somebody there at all times supervising it because that's super expensive. Having 24/7 staff or whatever your operating hours staff is impractical for most ranges. So condition number 2, it is the responsibility of the range operator to ensure compliance with Section 6 of the Shooting Club and Shooting Ranges regulations. The CFO states that no one may use the range or a restricted firearm or prohibited handgun at a shooting range unless they are a member or a guest. This condition is to make sure that the shooting range is aware of who is participating at the range. The range tracks users of the range through a logbook, and participants are obliged to sign in. This is a really common system. The applicant argues that it's the user's responsibility to abide by the regulations concerning what firearms they and their guests may use on the facility. Mr. Cairns stated that the biggest concern is that the facility is not staffed. Because of course it's not, most of them aren't. They do not check licenses at the gate. Most of their members have a license. However, a member does not have to have a license because they can come with a friend who has a license. The user supplies the firearms. Springfield does not supply firearms. It is the user who is responsible for their actions with their firearms according to their firearms license. In the membership application that every member signs, the safety rules and range procedures are included. The applicant must sign indicating that they have read and agreed to all procedures. Only current members in good standing have access to the code for the gate, and they can bring in a guest. The number of visits for guests is limited to 2 times before they are required to become a member, so just to try the place out kind of thing. Persons attending the range are required to sign in before they start shooting, and range rules are posted. Users must indicate if the range is active. If a user is there alone, they operate as their own range officer. If there's more than one person at the range at the same time, one of the members assumes the responsibility of being the range officer. Again, this is a super common system. This is basically what's done at the vast majority of ranges. This is specified in the rules and is also part of the regulations. There's also a chief range officer for the range responsible for the overall safety of the facility. If there's an incident, the chief range officer must investigate it, bring it to the board to determine if there's an issue. The board provides training for members to become range safety officers. However, the board members or the range safety officer are not always at the range. That is why there's a locked gate with a combination to allow members to come and go as they want. The board members and the range safety officers probably have their own jobs. They have their own careers and so forth. Their job isn't guy who runs range. They're doing this typically because they like the range and they just want to help support it and they want to help run it and make sure that there continues to be a range to shoot at. So, safety people are on site when they're running a club event. Nowhere in the Firearms Act nor in the Firearm Regulation and Shooting Club Regulations is it stated that it is the responsibility of the range officer to ensure compliance with Section 6 of the regulation. So that's not typically, the range operator's requirement. The CFO did not question the present system of tracking range users through a logbook, nor did she raise any concerns that the facility was not staffed. She did not indicate there were any concerns with the procedures and controls in place at Springfield to manage compliance. The CFO states that the range operator is responsible to take reasonable measures to ensure its users are members or guests of the club, and the CFO is satisfied that this was being done. It was argued by the respondent that if a CFO revoked approval because a range violated this section, then that decision would be reviewable on reasonableness, but the condition itself is not inherently unreasonable. All right, so the decision, Section 6 of the Shooting Club's regulations is entitled Requirements for Users. So not operators, not the CFO. This is requirements for users of range. That's their responsibility. No person may use a restricted firearm or prohibited handgun at a shooting range unless the person is A, a member or an officer of an approved shooting club, B, a guest of a person referred to in the preceding paragraph, or C, an individual who ordinarily resides outside of Canada and who is either a member of a recognized shooting organization or a guest described in paragraph B. The operator's logbook, lock gate with a code, and other measures as described are a form of oversight and control of the user, but not all-encompassing. To fulfill condition 1 and 2 as stated, it is the responsibility of the range operator to ensure compliance with Section 6. The operator would have to hire full-time staff. Since the operator is not mandated to be responsible for compliance under that section of the regulation, and it was not the intention of the CFO to mandate full-time staff at Springfield, and it appears she is satisfied with the procedures in place at Springfield, the condition that the operator ensure compliance is overbroad and therefore incorrect. Some of the responsibility thrust on the operator is the responsibility of the user under Section 6 of the regulation. Now, I'm just going to comment here because some people who are not gun people might say, well, wouldn't it be better to just have all of these ranges with permanent staff? And the problem is that once you do that, you increase the cost quite dramatically. Now, you actually want people to have access to ranges because, if you are not a gun owner, you probably think that it's a better idea that people are shooting at the range rather than like in the woods. And the other thing here is, you want people to have access to places to practice shooting to develop their accuracy. The firearms rules and the firearms laws actually contemplate that some of the people who are involved in, shooting and hunting and so forth may not be wealthy people. You might be talking about people who are sustenance hunters, who literally are reliant on hunting in order to feed themselves. There are special provisions for people who are illiterate and people in remote communities and various other things. So when you start putting up all these barriers, if you turn it into a rich people's sport, what you really do is you harm the most marginalized people who need access to these things. So if you say, okay, well, sure, we're just going to, have full-time staff, and a range membership will go from, a few $100s to thousands of dollars. Well, then really what you've done is you've priced out the poor, you've priced out, so I don't agree with that. When you see people saying we need to make it more expensive, well, what you're basically saying is that you don't like the poor. And I don't agree with that stance. So condition number 3, the approved operational hours of this range are from dawn to dusk, no nighttime shooting permitted. The CFO states that this is a prohibition on shooting at night. She asserts that the hours of operation of a shooting club must follow the hours for hunting as stipulated by the Department of Natural Resources and Energy Development. There are no Section 29 ranges under the Firearms Act in New Brunswick that have been given nighttime shooting approval. Except for one DNR authorized activity, there are no civilian nighttime shooting activities permitted in New Brunswick. Now, this is always sort of a problem because they set hunting rules, and sometimes those hunting rules are sort of overbroad and may end up capturing a lot of non-hunting activities. But we'll keep going here. The CFO testified that nighttime shooting is not safe. Ranges must have to ensure that projectiles do not leave the range. During daylight hours, people walking around the range would know there is a range. At nighttime, they would not know. She stated emphatically that there is no reason for a civilian, a New Brunswicker, to do target shooting at nighttime. Well, other than the fact that it might be enjoyable and, is a different sort of hobby and sport. The prohibition is about public safety for the members using the range and also for civilians that are passing by. Hence the reason why there is no nighttime shooting permitted. Now, do you remember that bit about how this is surrounded by swamp? Who trudges through a swamp at night towards the sounds of bullets? Like, you hear gunfire and you're going, I'm going to just slog through this swamp in order to get to the gunfire. This is kind of an unusual line of thinking in terms of civilians being under threat here. Springfield provided information in August 2020 with nighttime shooting procedures, Exhibit A11. The CFO does not accept this protocol. The CFO states lighting would have to be fixed and cannot be lanterns, flashlights, or lighting affixed to one's forehead. She is aware that law enforcement may need to practice nighttime shooting, but that has been provided at the Canadian Forces Base, Gagetown. Of course, law enforcement often likes to rent, other ranges, so they may not want to limit themselves to Gagetown. The CFO was not aware of the protocols with respect to nighttime shooting when Springfield's approval was granted. She's not aware of the policies or protocols for nighttime shooting anywhere or elsewhere in Canada, or if any exist. Springfield contends that the hours of operation are the responsibility of the operators and that this is a range operation issue. They carry insurance and have people to run events. The restricted operating hours identified as dawn to dusk impedes Springfield's intention to have low-light shooting or nighttime shooting events. It affects the opportunity to offer these activities to the membership. That is cool. I will, and so long as it's done well and, with lighting or whatever else, that seems to make sense to me. The nighttime shooting procedures, Exhibit A11, were designed specifically for handguns. These rules were not provided to the former Chief Firearms Officer, Mr. Hand, for consideration when the range application was made. Normally, range rules are not supplied because they are not required, as it is the operator's responsibility. Translation, not necessarily the Chief Firearms Officer's business, because it's the operator's task. A number of members have requested the ability to use the range in low-light shooting activities, utilizing flashlights and lanterns and so forth. Springfield did not provide the Chief Firearms Officer with the document Exhibit A11 night shooting rules until after the approval. The Board of Springfield have been discussing night shooting for quite a while, as they're getting more and more requests. They would ensure that there was lighting at the entrance to the range that was being used, and the berms would have to be marked by lights, including the side berms. There would be an illuminated safety table on the range where people could handle their firearms. So, seems sensible to me. You've got an illuminated sort of perimeter so you can see if anything's, if anyone's wandering onto the range, which of course nobody should be doing, but, if somehow it happens, you'd be able to see them. And, so that seems to make sense here. I don't have access to the full rules, but it looks like they put some thought into it. The applicant refers to Exhibit A15, Shooting Range Leasing Policy. This policy is with respect to ranges that are leased on Crown land, such as Springfield. Referenced at 8.9, entitled Other Uses of Shooting Ranges, it states that lessees may make shooting ranges available to DPS, DRD, RCMP, and other enforcement agencies for both daytime and nighttime firearm safety training or firearm qualifications. It also states that lessees shall open shooting range to the general public at times acceptable to the club holding the lease. It seems that nighttime shooting was specifically contemplated by the lease. That's a thing. Mr. Cairn stated that users want a challenge. Many are members of law enforcement, and this is another form of challenge to attract members to the club. Obtaining a firearms license and purchasing firearms is a heavily regulated process. Membership to Springfield is also heavily regulated. These users are enthusiasts and sports people. Decision. There was no indication that any activity would be carried out unless appropriate safety measures were taken. There is no logical reason provided why members of law enforcement must be obliged to go to Base Gagetown unless there are special reasons that make Base Gagetown the only range that can provide these services. However, there was very little information provided by Springfield except for a set of rules for low-light shooting. Similar to the CFO, the Springfield operator could not provide any information on low-light shooting procedures anywhere in Canada. This will be the next step, I'm guessing. The CFO compared the public safety issue of low-light shooting on a range as the equivalent to nighttime hunting. She provided for a reason that no civilian in New Brunswick had any reason to do target shooting at night. The public safety issue of nighttime hunting and the ban on nighttime hunting is not comparable to target shooting on a range in low light. There is nothing to substantiate the public safety argument of an individual happening upon this particular shooting range at night. Considering the placement of Springfield on a 30-hectare piece of land in the woods, it is implausible that any member of the public would be trudging around the range among swamp and trees at night. It would be inconceivable that a member of the public would then make their way over the earthworks of dirt backstops or berms to stumble onto the range. This does not suggest that public safety would not be a factor on other ranges in other locations with other configurations. So basically, looking at this specific range, it kind of seems unusual. Quite frankly, if somebody, did manage to sneak onto a range through swampland and forest at night where there was, the sound of gunfire and, was injured, I would say that this is a time to go and search their place to see if they left a note. Because that takes a lot of work to, and I'm not saying that there are not people who are both stupid and dedicated. Because, often the rule is when you idiot-proof something, some idiot out there will show you that they are extremely talented in their field and that they excel in idiot behavior. But this would be exceptional. I mean, you might as well start worrying about, what happens if somebody parachutes onto your range, or teleports in. So the Chief Firearms Officer's role is to ensure that the safety of the user and the public is the consideration. Reasons must be based on specific facts and information about low-light shooting at that particular shooting club. If the operators set up proper procedures and protocols to ensure that bullets remain in the cone of fire and do not escape the range to endanger the public or the users, then low-light shooting should be considered as any activity where proper safety protocols are established. Since there is already in place a low-light shooting range at Base Gagetown for law enforcement officers, it is unreasonable to make a wide-ranging declaration that this type of activity cannot be delivered at Springfield under any circumstances. The court finds the CFO's decision was not reasonable. The court holds that the hours of operation for the range is a decision of the operator. However, the CFO has an overriding authority to determine if there are reasonable grounds to believe that the continued operation of the shooting range may endanger the safety of any person. The respondent suggested that the court should apply Pogson in Alberta, where new evidence is raised at the hearing, in this case the safety measures listed in the nighttime shooting procedures provided by the court may refer the matter back to the CFO. So the CFO is saying the case law says that you can send this back to us to make another determination, and you shouldn't just immediately say that they're allowed to do nighttime shooting. Although the CFO did not provide reasonable grounds for a prohibition, the applicant provided the information on nighttime shooting after the approval, and it was not sufficient information for the court to make a decision. This court agrees that under Section 10.2b of the regulation and under subsection 29.3 of the Firearms Act, there is authority to request information about the nighttime shooting activity to ensure that this activity does not endanger the safety of any person. So the court says, I ordered that the matter be returned to the Chief Firearms Officer to be given the opportunity to review the matter more robustly and to allow Springfield to provide any additional information it sees fit to determine if there are acceptable safety measures in place to allow for nighttime shooting. So the court has not said nighttime shooting is okay. They've not said that nighttime shooting is not okay, but they've said that the chief firearms officer's original decision cannot be sustained, can't be upheld, and that basically they have to go back to the drawing board and come up with a new reason why they either need to approve it or come up with proper reasons why it can't be approved if they want to continue to, to refuse it. And if they provide those reasons why it can't be approved, that would allow for a new Section 74 hearing on those topics. Condition number 15. Targets shall not be placed on top of the backstops, and the center of the target shall not be more than 1.5 meters above the range floor. In order to ensure that the discharge of a firearm does not endanger the safety of persons on the shooting range or in the portion of the surrounding areas, the CFO states that the backstop is there to stop the projectiles. Backstop, that makes sense. If the target is placed on top of the backstop, then there's nothing to protect anything behind the target. Again, that makes sense. Reference is made to Exhibit A12, the standards. On page 13 at Figure 4 is the demonstration of a handgun cone of fire. If you are not a gun owner and you're thinking of what is a cone of fire, it's, you're aiming at a target, but maybe you're not very good. And so maybe you're going to miss the target. This is sort of an expected ranges of misses, including really bad misses. So this is not just like, a really good shooter shooting a group the size of a quarter at, whatever distance. This is maybe a newbie. This is maybe somebody who is not at their best, an unskilled newbie. So Mr. Cairns stated that there's no issue with the condition that targets shall not be placed on top of the backstops. Again, it sounds like Mr. Cairns is being 100% reasonable on that one. The backstop is there to stop bullets, so it is obvious you do not want to put anything on top of it. Furthermore, it is the operator's responsibility to see that bullets do not leave the facility. If you shoot over the backstop, bullets are leaving the facility. A member putting a target on top of the backstop would have their membership terminated because it is a safety issue. Under the New Brunswick range designs, the operator is responsible for the targets. It is also incorporated into the regulations by reference. The issue with respect to condition number 15 is the stipulation that the center of the target cannot be more than 1.5 meters above the range floor. For 6 of their ranges, this is not an issue. However, in 2 gallery ranges, the 600 meter and the 1000 meter, the gallery is at least 1.8 meters high off the range floor. The target sits on top of the gallery, and that is part of the standards. That is the way it is built. He refers to Exhibit A12, Standards for Design, entitled Outdoor Gallery Ranges at Figures 5 and 6. They reference the mantle to be 1.8 meters high. And his gallery is 1.8 meters high. It looks like it was designed exactly to the standards. That means it is 1.8 meters off the range floor. The reason for this is to protect people behind it who are identifying where you shot, or to protect the electronic targets. The center of these targets is 3 meters above the range floor. The targets are usually 6 feet or 2 meters by 2 meters. He asserts that there is no danger of the bullets flying over the top of the backstop on the 1000 meter range because there is a substantial drop in the bullet after it leaves the muzzle. So at 600 meters, the bullet drops over 6 feet. So for the non-gun owners, people tend to think of gunshots as traveling in a straight line. This is not accurate because bullets are, believe it or not, affected by physics. They are not magical objects that get to escape the laws of physics, and one of those laws of physics is gravity. So when you fire a bullet, that bullet is affected by gravity and is actually falling. The reason why it travels mostly horizontally is because you've put a lot of force on it. It's going real fast in the forward direction and less fast in the down direction. But it is going in the down direction. And so a bullet doesn't follow a straight line. It actually travels in an arc. So it's kind of like lobbing something at a target. So a bullet fired, in an upward direction isn't going to travel indefinitely. Gravity will bring it to Earth. There's also forces like drag that will slow it down over time. So essentially they're saying that because of this drop, that needs to be factored in when you're considering what is and is not a safe direction to shoot. So if you wanted to shoot over the backstop, you would have to aim 2 to 12 meters above the backstop. The reason for this is because the bullet has an arc on it, and when it comes down, it goes through the target. It's not going straight. It will strike behind the target 5 or 6 meters before it hits the range floor. The bullet will drop 4 meters on a 1000 meter range. In this type of shooting, one uses a scope with crosshairs, and each mark is a 3.6-inch drop for every 100 meters going out at 1,000 meters. Not necessarily, scopes are different designs, but close enough for what we're doing here. When one is shooting, they're going down 4 marks on the graduation to get the bullet to hit the target. So essentially, you've adjusted your scope so that it's firing up, and that the scope point of aim is essentially been adjusted to where it's actually expected to drop and land to. That's probably a terrible explanation, but oh well. So the scope points above the target, but the bullet drop compensates. The backstop at the 1,000 meter is 8 meters high. The technical requirement is for it to be at least 7 meters high. Any range over 300 meters has to have a 7 meter high backstop. The condition that states that the target has to be 1.5 meters above the range floor impacts ranges 8 and 9, the 600 and 1,000 meter ranges. So that extra meter of, a backstop is actually quite significant here, especially when we're talking about a deviation in allowed target height of 0.3 meters. I mean, just sort of basic looking at the numbers here, and I'm not running, ballistics math on this, because I am the wrong guy to run ballistics math. I'm a lawyer, not, any sort of accountant or the like. But that seems to me to make sense. So, decision. Condition number 15 has 2 parts. The first part is not part of the objection, as it is agreed that the targets are not placed on top of the backstops, as that would allow projectiles to escape from the range. So, of course, nobody's climbing up the 8-meter berm to put a target up there. I don't know of any range that allows you to climb on their berms in any event, because you don't want damage to the berms. Those are actually really expensive. You might think that a big pile of dirt doesn't cost a whole lot, but when you actually start talking about doing the earthworks to create a 8-meter tall wall of dirt, that costs a lot of money. It's not cheap to put an extra meter onto a berm. So, all right, so the second part of the issue of contention, as Mr. Cairns aptly described, how for the 2 gallery ranges, the center of the target is at least 1.8 meters off the range floor, but this is part of the standards of range design, and that is the way the gallery is designed. The bullet drops after it leaves the firearm, so at 600 meters, the bullet drops over 6 feet. One uses a scope that points above the target, but the bullet drop compensates. The backstop at the 1,000 meter range is 8 feet high. It would appear that the respondent is not suggesting that this item on the list of conditions was not being respected. So although condition number 15 gives the center target height of 1.5 meters, from the court's understanding, the respondent agrees that the 1,000 meter and the 600 meter range are in compliance. Springfield provided compelling reasons why the second part of condition number 15 was not reasonable, and I was not provided with any good and sufficient reason or public safety issue or regulation by the Chief Firearms Officer that contradicted Springfield. The condition is unreasonable as it contradicts in part a matter that is dealt with in the standards for design, and the respondent has not argued that Springfield is in contravention. So you can see the Chief Firearms Officer is really not having a great day here. So far, they've been found to be unreasonable on a whole lot of points. And in fact, when you start to break this down, like, this one kind of seems obvious here. It looks like, and this is from an outsider, but, based on what I can see in this case here, it looks like the Chief Firearms Officer had sort of their blanket standard conditions, and that they didn't actually look at what was going on at this particular range. Because if they had, they might have said, oh, well, sure, it's 0.3 meters up from what we'd like, but they've got an extra meter of berm. And, at these distances and with these sort of expected bullet trajectories, this should be fine. Doesn't look like they did any of that. And so the court is going to say, yeah, no, that's not reasonable. We're not going for it. So another point for Springfield. So far, they've got, 2 wins I've lost count. They've got a win on everything except for one, which is kind of a conditional maybe win. Condition number 16. Targets shall not be placed on the range floor to be shot at and shall not be positioned so that projectiles shot at the targets will strike the range floor. Condition number 16 is a highly contentious issue, as this affects what Mr. Cairns believes is an important activity at Springfield for teaching youth how to shoot and has been a practice for years. The CFO states that range floors are not designed to be a backstop. Striking the range floor will cause the projectile or bullet to ricochet, and one does not know the path of that projectile, which increases the safety risk. Ricochets can endanger the safety of the members that are currently shooting and others on ranges that are close by. In paragraph 22 of the affidavit of Mr. Cairns, reference is made to a youth shooting event involving tennis balls. The shooting activity involves tennis balls tossed downrange and are shot at with a .22. If the youth hits the target, he can see the target move. The bullet strikes the range floor. This activity has been done for years at Springfield Range without safety concern. The CFO indicated surprise at this shooting event. She stated that if you shoot at the range floor directly, that may cause damage and ricochet. One does not know the cone of fire or where the projectile will go. Springfield's concern with this condition is that when they run youth events, especially Boy Scouts and Girl Scouts, the youth are taught to shoot and receive firearms safety training. They are taught how to point and aim. They shoot their firearms from a sitting position, so they do not lift their rifle. They are paired with a range officer one-on-one. Besides targets that are hanging for them to shoot, they also have tin cans, ballistic targets bought at Canadian Tire, and tennis balls that one places on the range floor. These sorts of targets provide instant feedback to the shooter. The youth is able to see immediately if the target has been hit when the target moves. Youth do not like paper targets because they cannot see whether or where the bullet hits on the target from the range hut. They could shoot many rounds and then walk down and check the target and discover they have not hit the target. So a paper target is not the same enjoyment for them. I think that's a fairly fair summary there. Springfield has a properly designated range floor built to absorb rounds hitting it. The range floor is 0 to 3/4 inch or 0 to 3/4 crushed rock, and if the bullet hits the range floor, it will lose a substantial amount of its velocity. The range floor will either consume the bullet, or it will skip off and go toward the backstop normally at an angle less than that when it contacted the range floor. If only people had studied the ballistics of ricochets, which they have, and that's part of the consideration of what the range floors are designed to be like. There's reasons why they specify what the range floor materials should be. In addition, they have target frames that are placed forward so that on the 100-meter range, they can place frames at 25 meters, 50 meters, and 100 meters. The users may shoot at all the targets from the same position. Otherwise, the 25-meter targets would block the shooters shooting at 50 meters, and 50-meter shooters would block those shooting at the 100. This is also for the benefit of the shooters to allow them to shoot at different distances without having to walk down range. This is partly a safety factor and allows more people to use the facility at one time. So just good design. Standards of design provides that targets should be placed as near as possible to the backstop, but this does not mean the target cannot be placed forward as long as the shooter's line of fire is directed to the backstop and the cone of fire is captured within the backstop. In addition, the applicant directed the court to standards of design at 1.3.4 safety area, which describes the importance of range floors for the purposes of safe discharge of firearms. It's always nice when their own design documents kind of contradict the argument they're making. This is something you generally want to avoid if you're in court where your own documents are what undercuts you. So in order to prevent or minimize ricochets, special attention must be given to range floors. See range floor in section 2.4. It should be noted that a bullet loses a high percentage of velocity upon first contact with a well-designed range floor, and if it does ricochet, it is generally lower than the angle of incidence. And further, these standards have been developed to contain all rounds within the firing range boundary between the firing line and backstop. Should ranges meet this design and use standards, no rounds will leave the active range area, eliminating the need to use safety templates. In the same standards of design at 9.10, page 59, entitled Targets, it states, the selection of target types for use in outdoor ranges is at the discretion of the range operator. Further, in this section, it cautions that hard targets should be critically evaluated to ensure users are not put at risk as a result of the use of inappropriate use of hard targets given the range design. Little bit of clumsy language there, but it happens. The minimum engagement distance for hard targets is 10 meters. He stated that although they do shoot hard targets at closer distance, the targets are built to deflect the rounds down, and rubber barriers are used to protect the lower extremities of the person in case of ricochet. Decision. In the Standards of Design at Chapter 9.10, it states that the selection of target types for use in outdoor ranges is at the discretion of the range operator. It is clear that target selection is the authority of the operator. The CFO objects to placing them on the range floor. The operator argues that the range floor is specifically designed to prevent ricochet. The operator is experienced and has carefully considered the safety of the users. The range floor is designed to take the impact of projectiles, just as the entire range, including the berms and backstops, are built to withstand the impact of bullets. In all the many years this activity has been going on, there's no indication of any concern brought forward by any range officer or any person teaching these youth how to handle firearms. The range floor would be hit regularly with stray bullets, and this is the purpose for the specific design of the range floor and the reason that upkeep is necessary. The youth are described as sitting down so as not to have to carry the weight of the firearm, presumably to allow for a steadier hold and a better control of the firearm. I find myself wondering if this particular justice or judge might have been a shooter, or if not, they have a really good grasp on sort of what's going on, and I commend that. The tennis balls are at a distance, downrange, the youth are shooting low-caliber rifles, and the seated position would allow for a safe angle so that any ricochet would be contained. The concern by the CFO for the safety of the user is not based on reasonable grounds, and the danger to the user is improbable. Note that the danger, you never have a standard of zero danger, because everything is dangerous. You don't have zero danger if you eat a hot dog. You don't have zero danger if you drive down the street. I am not in zero danger right now, sitting in my chair in my, home office. There was on the news, a satellite is going to crash to Earth somewhere. Well, that could come through my ceiling. I'm not in zero danger right now. But so the standard is never zero danger. It is minimal danger. So the CFO does not have the burden of proof, but the applicant has provided more than sufficient information to establish that this activity is safe. It is not reasonable nor within the authority of the CFO to overrule the choice of target by the operator as contemplated in the standards of design unless there is evidence that this practice is not safe. Lovely. And so one thing I find myself wondering is if they're going to update the standards of design now in order to basically amend all of this stuff and try to remove all of the bits that they don't like and to try to change the standards of design to match what they wish the law said. We'll see. But in any event, this will be a historical document and could then be, referred to as like, why did they change this? Oh, right, they lost a court case. This would not be the first time that sort of update has happened. When court cases were lost in Ontario about, rules with respect to where you can take a firearm with respect to an authorization of transport. Part of the reason why they lost those was because of essentially practices in other provinces. The result of that was that they said, hey, other provinces, you've got to change your practices so that, now people can't make reference to that. So this is just sort of idle musing, but it would not surprise me. It seems perfectly a possible outcome here. That said, there's always going to be, pushback. That's not a reason not to fight. In fact, that's a reason why you pretty much have to. Condition number 25. At the discretion of the Chief Firearms Officer, the shooting range may be inspected to ensure continued compliance with the requirements referred to in the regulations and to maintain public safety requirements. So basically, they want to write themselves a provision that allows them to inspect when and how they feel like it. Now, this could be a big deal because, in theory, this permits things like unscheduled walk-on inspections where they just show up. And of course, those are going to shut down the entire range because the inspector isn't going to be able to go and check things out downrange and so forth without shutting the range down. So you might be having, whatever. I see they do cowboy action, so maybe there's a cowboy action event and they say, nah, we're doing an inspection instead. Now, the regulations actually provide for fairly strict limitations on when ranges can be inspected. But what this condition basically says is, we want to write ourselves more power. We want to write ourselves powers that the law says we don't have, but we'd like to invent that we do. So that's a concern, right? Ms. Rosignol explained that the Chief Firearms Officer will be notified if there has been an injury at the shooting range. If this happens, there is a report to complete and an investigation is done. At that point, the Chief Firearms Officer decides whether an inspection is done. If there is a change report wherein changes are made to their range, they are to notify the Chief Firearms Officer so that an inspection can be performed. If there are any reasonable grounds to believe that the continued use of the range may endanger the safety of the public, an inspection can be performed. This is the reason that condition number 25 is included. The Chief Firearms Officer is not aware that the office has ever inspected Springfield outside of these parameters. The Chief Firearms Officer agrees that her discretion to inspect ranges is limited by Section 9 and 10 in the Shooting Club and Shooting Ranges regulations. So they're saying, well, we're only going to inspect under these narrow circumstances. Well, then why are you writing such a broad provision in? That is concerning, right? The applicant submits that this condition purports to allow the CFO to exceed her authority. And I would agree with that. On the plain reading of that, that's exactly what it seems to say. The regulation does not allow for inspections at the discretion of the CFO. In fact, it specifically prevents that, unless it is part of the approval process or part of an investigative process if there is a reported incident. The CFO agrees that she is bound by the regulation. Then again, why are they putting in conditions that say, or seem to say otherwise? Decision. The inspections under the regulations are for a specific time period, and nothing in the regulations allows for the office of the CFO to walk in and do a random inspection at the discretion of the CFO, unless it falls under one of the issues or concerns indicated in the regulation. Subsection 10 sub 2 states that the CFO may request evidence of compliance more frequently if he or she A, has received in the preceding month an injury report or a change report, or has reasonable grounds to believe that the continued operation may endanger the safety of any person. Now note, that's requesting evidence. That's not actually necessarily contemplating an inspection. The CFO has no personal discretion to determine when to require evidence of compliance and thereby inspect the shooting range. Her authority is strictly regulated in this condition in the approval stating at the discretion of the Chief Firearms Officer does not accurately reflect the regulation. This condition is, therefore, not within her authority and does not meet the standard of correctness. So basically, they're trying to write a condition that would give them more power. They're not allowed to do that. No, not allowing that. That's out. Condition number 26. The use of exploding targets is not authorized on the shooting range. Exploding targets being tannerite, that sort of thing. The CFO explains that exploding targets are a safety hazard as the direction or flight path of the fragments once exploded cannot be determined. However, many of these are made out of paper, and so the fragments of a paper target are not exactly a danger. There's nothing in the Firearms Act nor the regulations to prohibit exploding targets. The Chief Firearms Officer agrees that the range standards do not address the issue. However, the Chief Firearms Officer believes that exploding targets are a public safety risk. I will note that explosives, the explosives group does not believe that because they allow these things. Now, I mean, that varies, right? If you have 40 pounds of tannerite, that would be a public safety risk, most likely. But many of these targets are little, just small paper things. They make a small bang. They're not, a big explosive or anything like that. So this is a bit of a question here. She agrees that under shooting range standards, it says targets, the selection of target types for use in outdoor ranges is at the discretion of the range operator. She agrees that exploding targets can be purchased legally and shot and exploded legally in New Brunswick. However, she states it is illegal to shoot exploding targets at a range because it is in the conditions that they cannot explode targets on a range. So remember how they were previously saying that it was just reasons for, that these are just reasons for the approval and maybe not counting as, conditions? Well, now they're saying that they're conditions. So we've got kind of a contradiction here, and that's always a bit of a problem. So, and the other thing is when we're saying that the conditions, should be changed, saying, well, it's illegal because it's in the conditions, is kind of trying to eat your own tail here. So the applicant states that Springfield does not allow exploding targets on the facility, and not because of safety reasons, but because of damage these targets do to the rubber mats and equipment. Their issue with the condition is that it is the operator's responsibility to select targets, not the CFO. So they're not saying, hey, we want to have exploding targets on a range. They're saying, hey, mind your business. Like, you guys have a specified set of authority, and you guys can run that, but this is our authority. You can't take our authority away from us. This is given to us by the law. So Mr. Cairns testified that the exploding target is perfectly safe if you use them based on the operation instructions. They are sold to the public at various places such as Canadian Tire. They come in various configurations such as Firebird, which is very small with an adhesive patch on the back, and it can be placed on a tree in the woods. It is legal to do this as long as you have a hunting license. Another target, tannerite, is a biochemical and it is a much greater explosive, but they are still legal in Canada and not regulated by the Explosives Act. They have potential to damage Springfield's property as they would blow a hole in a rubber mat, so they are prohibited. A number of ranges in the province would also take the same position and ban them. In Exhibit A7 at page 84, Mr. Cairns provides a photo of the range rules where it indicates on a large sign at the entrance to the facility that Exploding targets prohibited on all ranges. The objection to this condition is not that Springfield wishes to permit exploding targets. On the contrary, they are banned, but they contend that it is not in the authority of the Chief Firearms Officer to ban them. The respondent argues that this condition was another example of the fact that the range received approval because exploding targets were prohibited on the shooting range. This condition was one of the reasons for approval. So, neither side here really wants exploding targets on the range, but they're saying we want to protect that this is our decision to make. And again, we see this kind of wishy-washy thing between, is this a reason? Is this a condition? Because they're saying it's a condition that has legal effect and that, creates an offense. So decision, the Chief Firearms Officer's reasoning is that these explosive targets are not safe, in spite of the fact that anyone in New Brunswick with a hunting license can purchase them and use them for target shooting. If used according to the directions, they are not considered a public safety issue in New Brunswick, otherwise they would be subject to stringent controls or banned. The real issue is who has the authority to ban this type of target at a shooting range. In the standards for design, it is clear that the choice of target is for the operator to decide. The operator has made it clear that these targets are prohibited because they do damage to the mats to which the targets are attached. It is within the operator's authority to ban these explosive targets, and he's done so prominently displayed on the rules at the entrance to the range. It therefore begs the question, if these targets are banned at Springfield and under the proper authority of the operator, why does the Chief Firearms Officer add this to the conditions? The Chief Firearms Officer always has an overview with respect to the safety of any person on reasonable grounds to believe, but if the targets are banned, there is no reasonable grounds to believe any person's safety is endangered. The operator has properly used his discretion to prohibit the use of these targets, therefore the condition for approval is not reasonable. So essentially they're saying, they're already banning them, but you can't take that authority away from the operator when they're exercising it reasonably. This makes no sense. This is basically just a power grab, and it's not happening. So, arguments. In general, Springfield objects to the conditions on the approval not because they're in disagreement, but because many of these conditions are in the Act or regulations. For example, condition number 4, the obligation on the operator to post a copy of the range safety rules, and condition number 6, that the range operators and members shall comply with the shooting clubs and shooting ranges regulations, are already in the regulations. In addition, the operator argues that conditions number 7, 8, 9, and 11 are not challenged, but these conditions are found in the standards for design. Condition number 12 is in section 11 of the regulations. Condition number 14 is a rule imposed by the Board of Springfield. Condition number 18 is not challenged, and this concerns the maintenance of the backstops, berms, and baffles, and is the responsibility of the operator. With respect to condition number 19, it is not challenged, but Springfield argues it is too broad, as changes to the operating conditions may have to be reported to the CFO, but it depends on the changes. In any event, this condition is covered under section 12 of the regulation very specifically, and it specifies proposed changes affecting matters submitted in documentation under subsection 3 sub 2 shall be reported in advance to the CFO. So this is showing that a lot of this is basically rules that already exist, and where they're essentially trying to write it in as conditions as well. So the range condition number 5, the range operators must ensure that all users of the range comply with the range operating instructions. Mr. Karen states that they cannot ensure compliance with the range operating instructions because they're not always on the range, and the regulation does not require this. So this would again be a rule that would require them to set up 24-hour or however long, permanent staff. Every member is aware of the operating instructions. They have read them as they are provided on the back of the applications, posted on the website, and posted on a 4x8 sign at the range. Users are expected to conduct themselves accordingly on the range. If they come across a situation where the user is not complying with the rules, an incident report is completed and provided to the Chief Range Officer. The board reviews the report and advises the member of the issue. Depending on the nature of the incident, there could be a warning, or membership could be terminated, and I don't think there's a range out there that doesn't follow similar things. If there's somebody who's behaving unsafely, they'll say, you're done. You can't continue to use our range. With respect to all the conditions in general, the applicant questions the authority of the Chief Firearms Officer to add any conditions on the approval, and this because they argue where conditions are permitted in the Firearms Act, they are specified. For example, under Section 58(1) of the Firearms Act, it specifies that for the purposes of issuing a firearms license, an authorization to carry, or an authorization to transport, a Chief Firearms Officer may attach any reasonable condition to it that the Chief Firearms Officer considers desirable in the particular circumstances. Note that that's a limited category. firearms license, authorization to carry, authorization to transport, not range approval. The applicant cites Rizzo and Rizzo Shoes as a guide to the interpretation of statutes. Mr. Justice Sakaguchi, at paragraph 21, cites Elmer Drieger in Construction of Statutes. Today, there's only one principle or approach, namely, the words of an act are to be read in their entire context and in their grammatical and ordinary sense harmoniously with the scheme of the act, the object of the act, and the intention of Parliament. The respondent argues that all of the conditions listed in the requirements for approval at the time of the approval were being complied with, and that is why the approval was granted. If the applicant wishes to modify their approval to allow for activities currently precluded, they need to file a change report. The operator must comply with the design and operation of a shooting range according to the requirement of Section 5 of the regulations. Section 5 is the key source of the authority of the Chief Firearms Officer. It is not the exclusive responsibility of the operator, as the Chief Firearms Officer has responsibility to ensure compliance with the regulations. The respondent cites Vavilov at paragraph 15. In conducting a reasonableness review, a court must consider the outcome of the administrative decision in light of its underlying rationale in order to ensure that the decision as a whole is transparent, intelligible, and justified. What distinguishes reasonableness review from correctness review is that the court conducting a reasonableness review must focus on the decision the administrative decision maker actually made, including the justification offered for it, and not on the conclusion the court itself would have reached in the administrative decision maker's place. So that's again getting to the reasonableness aspect here. And so they're saying what this says is reasonableness is not that you have to actually look and say, is this decision one that they, took the right steps for, that they can justify it? Not that it's the same decision you would have made. So you can say, I don't agree with this decision. I think it's the wrong decision. But so long as you can say, well, I can see how they get there, and how they get there makes sense, that it's a justifiable decision, even if I think it's wrong, reasonableness review says that that decision stands. So that's kind of the distinction between a correctness decision, where if the court says we would have come to a different decision than on correctness, they will reverse. So decision. Although the Chief Firearms Officer exercises broad powers under the Firearms Act and regulations, there is a division of responsibility and authority, and the Chief Firearms Officer must remain within her authority and respect the legal framework and the responsibility of others as stipulated in the regulation. Conditions in the approval should have an underlying policy reason that falls within the discretion of the Chief Firearms Officer. So no, you cannot take on more power than you have been given. That division of powers is by Parliament. You can't decide that it's wrong. And I think that this is a constant problem that we see with Firearm Act cases, where they seem to think that they don't like the law as it's written, and they basically want to treat the law as though it's doing something else other than what it does. I have issues with that, and I'm really glad to see this court, I think quite correctly, is saying, no, stay in your lane. You guys interpret the law. You don't get to rewrite it. You don't get to make new law. Although some conditions directly cited the regulation and therefore did no harm, they were unnecessary. However, other conditions actually misconstrued the division of responsibility and authority in the regulation so as to pass responsibility to the operator that was the responsibility of the user, and extended the authority of the Chief Firearms Officer, suggesting more authority than was contemplated by the regulation. Right there, that sort of sums up exactly what's going on. They're wanting to foist more responsibilities on the operators and basically make the operators on the hook for if a user does something, that is wrong. So ordinarily, if a user does something improper, the operator bans the user and that's it. But if it's now the responsibility of the operator, then the operator can be held to account when the user does something wrong. That's a bit of a problem, right? If I'm a car rental company and I find out somebody's, driving drunk, we take the car back and we ban them from using our services going forward. But the car rental company shouldn't be on the hook if somebody who rented a car ends up, driving drunk, unless somehow they were permitting it, or, if the guy walks in and he's got, booze on his breath and is staggering and has a bottle in his hand, then maybe there, could be an argument there. But simply saying that they have to police every single person who's driving is impractical. It's unworkable. It would be unfair. Same thing applies to ranges. And again, we don't want the chief firearms officer simply deciding that they have powers that are not given to them. That's not how the law should work. So conclusion, the policy reason for attaching the requirements on the approval was based on concern that there were too many ranges not passing approval. The chief firearms officer discovered that Nova Scotia had implemented a practice of attaching conditions to their approvals. The Office of the Chief Firearms Officer in New Brunswick felt that this would be helpful as guidance to the operators. However, these conditions did not respect the governing statutory scheme and were not internally logical. The conditions should be justifiable, transparent, and meet the standard of correctness. Had the Chief Firearms Officer decided to attach a copy of the regulations, or in the very least, properly cited the regulations, then Springfield would have no argument, because although copying and pasting the regulations on the approval is unnecessary, it would at least be accurate. Damn. That's some heavy language right there, right? So, it would at least be accurate. I love this bit. But the set of requirements or conditions is ill-conceived. Some are copied directly from the regulations, some improperly paraphrase the regulations and actually enhance the level of responsibility or diminish the authority of the operator. Other conditions are found in the standards of design. It is clear these conditions have caused confusion. Some issues that Springfield believed the Chief Firearms Officer objected to were apparently not the case. This is due to the wording of the conditions that led Springfield to believe they were burdened with greater responsibility or some responsibility had been taken away. Conditions that use language that improperly summarize the legislation or regulation, such as must ensure, do not meet the standard of correctness. Again, that's some really great language here. The Chief Firearms Officer should respect the authority and responsibility of the operator as per the regulation, unless there is good and sufficient reason to overrule the operator as is prescribed by the Act and regulations. Conditions are a form of refusal. Conditions attached to a Section 29 approval were not envisaged by the Act. Certainly, these conditions did not respect the statutory scheme. The Chief Firearms Officer should provide reasons for refusal, not for an approval. Providing reasons would force the Chief Firearms Officer to thoughtfully consider the rationale behind the conditions and do so within the legal framework, considering the relevant statutory provisions and regulations. The conditions attached to the approval did not meet the standard of reasonableness and were not justified. Those conditions that misinterpreted the regulations or the standards of design did not meet the standard of correctness. All conditions in the approval are hereby removed, and the question of low-light shooting must be reviewed by the Chief Firearms Officer to determine if acceptable safety measures are in place. So that's a thing, right? So the next question I expect people to have is, Runkle, you spent almost 2 hours on this case. Why is this case so important? And frankly, I think this one is a really big deal. This is one gun club bringing a challenge. However, the principles articulated here can be applied to other clubs. We've seen that in New Brunswick, they basically said that this is something they're trying to impose on all the ranges there. Well, I can guarantee there are some other ranges who maybe should be looking at this going, we could do that, right? I mean, why not? We've heard that these are rules that are brought in and being borrowed from Nova Scotia. I'm sure there's some people in Nova Scotia looking at this right now going, how about we get some of that? They've been applying some of this in other provinces as well. And the main thing is that this is one of the, it's a decision that actually kind of curtails the power of the Chief Firearms Officer to what they're actually given in the law, as opposed to the things that they would like to have. I have concerns that it seems like sometimes the courts are unwilling to hold the police to the four corners of the authority that they're given. But of course, that is what should happen. Nobody should be permitted to essentially write their own favorable laws. That's just not how the law works. The law should, it gives power to the police, but it also constrains them. The only real procedural fairness that we have is found in these laws. And if the courts aren't willing to make decisions like this one, where they hold them to account and hold them to standards, then we don't really have any protections. Now, I think that this decision, because it's so important, might be subject to an appeal. I could very much see that they will not like this decision. They'll want to challenge it because they don't want to open these doors. So that may happen. That requires us to consider, how do we think this case is going to do on appeal? And I think this case is going to do pretty well. It looks at it, it looks at the underlying statutes, it looks at the reasons for it, and I think it quite well articulates the issues, it articulates the reasons. I think this is a good, solid case. One of the things I dislike most is when there's a case that is really good for me in terms of the result, but the reasoning is shaky, and you just go, oh no, because you know that one's going to go to appeal and they're going to flip it. And they're probably going to flip it and not say, well, we don't like the reasoning, but we like the result. They're probably going to flip it and get you to the opposite result. So I don't like cases like that, but this I don't think is one of them. I think this one is really persuasive in its reasoning. You can never predict appeals courts. Sometimes they do things in directions you don't know, but I think this one has a very good chance of standing up to appeal. Now, as I said, might get appealed, and if it does, there will probably be a need for fundraising to fight an appeal. So if that happens, you will hear me say, hey guys, let's pony up some cash to help out on this one. And when I say let's, the old joke is when people online say, we should do something, we means you guys. No, I'd be first in line to put some dollars in on this one, because this is a big deal, and I really want to see this decision hold up. I also want to, commend the people who were involved, the Springfield Club, as well as Mr. Cairns, Mr. Abbott, the other people involved. They all did tremendous work on this. Mr. Abbott clearly has a very strong grasp of what's going on here. You can see when you're a lawyer and you've read a lot of case law, you can sort of see the patterns. It's almost like doing tool mark analysis. You can see kind of the shape of a lawyer's arguments and where those arguments have left marks in the decision. And I can see that all throughout this. I can see places where it's just like, this was clearly a very well articulated argument and it carried favor. So I have nothing but the highest praise for Mr. Abbott and his work on this one. Fantastic work. I'm super thrilled. I'm also really pleased, and I mean, I didn't do any work on this file. I can't claim any credit. I didn't do any of the heavy lifting, but I'm really pleased to see my Runkle v. Alberta case was referenced here, was referenced positively, and helped bring about a positive result. I mean, that's part of why I think it's important to hold the chief firearms officer, the registrar, etc., to account, is that otherwise we get bad law. And so I'm really glad that case was able to have that effect. So that when I read that, I just kind of, you get a warm, fuzzy feeling. You get a smile on your face. It's, you've done something. And yeah, that made my whole day. Just absolutely. Anyway, thank you for watching. Please let me know in the comments below if you have any questions. I know this is a long video. I hope I explained things clearly. Let me know what you think. I think this is a fantastic case. I'm really excited about it. This is great news. I also want to thank my Patreon supporters at the $50 level: Jason Elliott, Demo, Canada's National Firearms Association, North Central Process Service, Kyle Martin, Jean-Guy Toussaint, Ivo Nedev, the CCFR, bcamf.org, Andrew Schaefer, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Matt Ward, Mark Whittington, Dale Nesbitt, Cameron Johnson, Andrew Elsich, and Adam Meester. I also want to thank everyone at the $10 level who will be in the crawl immediately following. Thank you once again. I hope this has armed you with knowledge. And as I said, I do want to finish up the Mr. Senior case. That one's going to be a long one, but the facts on that are crazy, right? So I kind of want to get through that one. And there's also going to be an entrapment proceeding coming up on that one. And so I want to sort of set the stage because I'm really going to want to cover that entrapment proceeding. I think it's going to be fascinating as well. Anyway, thank you for watching. I hope this has armed you with knowledge. See you next time.